Hi, everybody. Welcome to our panel, International Pathways to Local Justice in the Gambia, which is hosted by Global Rights Compliance. We've got one speaker who is hopefully still joining us in from the Gambia, but I'll get started anyway, and hopefully that she can join us in a minute. So first of all, I just want to extend my warm wishes to all of you during the pandemic, and I hope that you are all safe and well in these times. I'm going to briefly introduce GRC and our speakers, and then we'll get straight into the panel. So my name is Jordana. I am one of the senior advisors with Global Rights Compliance. We are a foundation staffed largely by international criminal, humanitarian, and human rights lawyers, and we're based here in the Netherlands. A significant portion of our work is focused on building the capacity of different justice actors to investigate and prosecute violations of international criminal and human rights law. And one of the ways that we do that is by using our own in-house resource called the BIS, which is short for Basic Investigative Standards. And that is available in both a manual and app form. So going to give a quick introduction to the BIS because it does form part of our project with KMF and also this panel, but I'll be quite brief. So the BIS was born out of GRC's work in Ukraine when we were working with investigators and prosecutors on how to investigate and prosecute international crimes. And what we found in the course of that project was that the guidance available to them to either collect evidence to a useful standard or to prosecute violations that were complex were not really available. They were either too complex or resources weren't available in their native language, or contextually, they weren't very relevant or very useful. So in that situation, for example, there was almost no guidance to be found on what would really practically assist investigators on how to work within an occupation, which was by then the Russian Federation. So this was an issue that we were seeing over and over again in our work, that in different regions and in various actors, whether it be civil society organizations or national prosecutors, there wasn't very practical or context-specific guidance on how to support them in effecting their mandates. And that's when we developed the BIS. And really it's sort of a model of where we take a very people-centered approach, and we work alongside criminal justice actors, and we provide them with very practical guidance on how to affect their mandates. But we do this by marrying domestic and situation-specific context with international best practice. And alongside of the BIS, whether it be in manual or app form, there's also associated mentorship to ensure that the transfer of legal skills is done sustainably. So this package is this contextualized resource, and the mentorship was really the basis of our project with KMF in the Gambia, where the main beneficiaries were prosecutors within the Ministry of Justice. And so what the project did was supported the prosecutors within the MOJ by working with them to develop a contextualized BIS, which is what we call the BIS Gambia. And that focuses on investigating and prosecuting some of the really complex violations that have come out of the Jammeh regime. And that is a resource that's available in both manual and app form. And of course, alongside of that, we provided the mentorship activities. So in this panel, we want to talk a little bit about how we should be taking a culturally situated approach to understanding criminal justice and what the challenges are that are associated with that. And so that section of the panel is going to be presented by our two wonderful Gambian speakers, Fatou and Naffie, and then Ruby, who on behalf of GRC is going to wrap up with a few of the lessons learned on how GRC married the domestic and international approach to criminal justice through the BIS. And because it's quite a broad project, thematically, we've decided to explore this in relation to sexual violence crimes. So we're going to listen to the speakers and then close with a Q&A. So there's two ways that you can submit questions during this panel. The first is going to be by downloading the BIS, the global BIS, and it's free, so we're not going to charge you to ask questions. But if you go into any Apple and Android store and type in GRC BIS, B-I-S, then the global BIS app will pop up, and through the Contact Us feature, you can submit some questions. And this is a feature that's also available to any users as well. But I'll be receiving your questions that way, or alternatively, you can just pop it into the chat box and I will be following along with those as well. So we'll close up with some of those questions. Now, before we begin with our speakers, I'm going to show a few clips from the Gambian Truth Commission, which is going to give you just a little bit of exposure to some of the live issues that came before the TRRC proceedings. And it's a body that the GRC and the BIS refer to really heavily throughout their project. So if I may turn us over to playing those clips.
Something in more detail that you mentioned earlier, which is the culture of silence. You mentioned a few issues in the beginning about because of the way the society is, there's certain conversations that people don't have, certain taboos. But if we can just focus more on the culture of silence and the different forms in which it is manifested in Gambia, I think that would be very helpful.
Yeah, the culture of silence in the Gambia is something that we are socialized, because if something happened, particularly sexual violence, people don't want to discuss about it. And because they don't want to discuss about it, it's difficult for the case to be reported. And that has resulted to serious underreporting of the issues of sexual violence. Even if you hear the rumors, sometimes it will not go anywhere. It will be put under the carpet for the fact that either the parents or either the child is not comfortable for this case to be discussed. So, and then because of the people who maybe the perpetrators are somebody who is well known or who is a prominent person or who is rich or who is a community leader, people have to be silent over it. So the culture of silence continues even people in their professional work. It affects them, the culture of silence. Because sometimes together they will go to the police to discuss for them to withdraw that case because they don't want anybody to know about it. Nobody is forcing people to put up their case. But cases that are of high crime, I believe that police should continue, no matter what. They should continue. But the culture of silence all over encourages the issue of gender-based violence to continue. Even the other forms of gender-based violence, for example, physical violence, the culture of silence. Even if a woman is battered by her husband or whatever, the first person you want to report to maybe is your mother or maybe it's an elderly woman. But most of the time, the response you will receive is, go and bear. Don't you know that we all went through this? What is wrong with you? For your husband to batter you, is there anything wrong with that? It means violence is being condoned, because that's what you are told. Do you know how many times my husband battered me? I know the multiple indicator cluster survey, commonly called MIX. It came out clearly, women themselves say that their husband can batter them if they cook and burn the food. If they go out without taking permission, they should be battered. So automatically women themselves accept it. But it doesn't mean that they accept people to violate them. It's because that is how they are socialized. They are made to believe that. Because I always argue, no woman, no human being would want you to inflict pain on her. But that is how you are battered. You are made to believe that. So I always say, look, this is not the woman speaking. These are the people in power who put this into the head of this woman. I don't believe this. That's what I normally say. And that's my belief.
something in more detail that you mentioned earlier, which is the culture of silence. You mentioned a few issues in the beginning, something in more detail that you mentioned earlier, which is the culture. What are some of the challenges that we have? I'd like to start first with the misconceptions about sexual violence, because that has an impact in terms of the reporting, but also in terms of how those cases are addressed. You mentioned some earlier, but I would like you to elaborate more on these misconceptions.
The misconception about gender-based violence in general, particularly sexual violence, is that many people believe that those who are violated sexually is because they are not cultured. Some believe that because of their dress code, that is why they are being violated. Some also believe that adult women cannot be sexually violated. Some also believe that parents cannot sexually violate their children, or brothers cannot sexually violate their sisters. Some also believe in that. So all these are misconceptions about sexual violence in the Gambia.
What are some of the challenges?
But I just lost a part of me, and it was just a feeling of lost, like someone died. And I think the perfect word to use, as Mandinkas will say, suno tale, and just lost.
Thank you. So I'm now going to pass the panel over to our first speaker, which is Fatou Baldeh, and she is the founder and the CEO of Women in Literation and Leadership, which is an organization that addresses violence against women and children in the Gambia and provides psychosocial support to victims of sexual and gender-based violence. So she is going to discuss a little bit about the barriers faced by women in accessing justice in the Gambia, and also how justice can be enhanced through the use of culturally relevant victim-centered practices. So over to you, Fatou.
Hello, good afternoon. Thank you for inviting me. I hope you can all hear me well. I was having a little problem with my internet connection. I think it's okay now. So listening to Hadi's video actually makes my presentation a lot easier because she has covered the video covers a lot of the issues that I would have liked to address. So my name is Fatou Baldeh, and I am the founder of Women in Liberation and Leadership. Well, we are a women-led organization, and over the past 2 years, we've been working with victims of SGBV, particularly during Jammeh's era, to support them in sharing their stories and to support some of them to access the TRRC and give their statements. So I will talk a bit about the work that we do. Okay. Is someone helping me with the slides, or shall I? Yeah, perfect. So I think Hadi's already explained some of these in her video. One of the biggest challenges we have in the Gambia is that we are a small community. The country is less than 2 million people. Everybody knows each other. So it's a closely knitted society, which makes it very difficult for victims, especially those of SGBV, to come out publicly to share their experiences. We also have a very conservative society, very religious, and we have deeply rooted cultural beliefs and practices that has an influence on how women come out, how women share their stories. Also, the view of women in Gambian society, the status of women, the low status of women in the Gambian community is manifested by low level of education, high maternal mortality rates, high level of other forms of gender-based violence, such as female genital mutilation, child marriage. All of these can also be easily linked to how Jammeh's regime condoned all these practices. We had, for instance, the female genital mutilation was practiced in the country, and a lot of people use culture and tradition and religion as a reason. And because of that, the government, Jammeh's government, didn't ban female genital mutilation until just briefly before he left, few months before he was voted out. But all of that was strongly based on cultural and traditional beliefs. We also have serious culture of shame and stigma. So when women speak out, when women talk about experiencing any form of sexual violence, there is a lot of attack. For the people who have been following the Gambia TRRC, every time a woman came out and shared her experience, we've had instances where women have been promised off-camera hearings and their identity has been leaked out on the media. The media has used pictures. For instance, we've seen Ms. Tufa Fatmata Jallow, who's just testified, and her image was used and the ex-president, and they were caricatured on the media. They were attacked. We've seen women who were forced into the HIV treatment. They were attacked because of their HIV status, because of the treatment that they went through. So instead of them being seen as victims, they were shamed and attacked all over, on TV, on national debates, on radios, on social media. Their families were attacked, and because of those reasons, this causes a lot of barriers. So for women who actually do want to come out, when they see these examples of what happened to other brave women who come out, it puts a lot of women off from taking part in the process. If we go to the next slide, please. When it comes to existing investigation on SGBV in the Gambia, from experience, because we work a lot with victim community, a lot of women feel that the method that the TRRC takes is not suitable for them. So you expect a woman to come to the TRRC, to the center, which is quite, it's not decentralized. We have the main TRRC in the middle. So women were expected to go and give their statements. So a lot of these women, the people who perpetuated the crimes against them, still hold influential positions. They worry that when they go to the TRRC, they may be identified, even if they don't want to testify, but they just want to give their statements. It's difficult for a lot of women. The TRRC does conduct outreach activities where they go into communities to give statements. The problem with that too, for a woman to, which takes me to the next point, for a woman in the Gambia to participate in the TRRC or to give a statement doesn't entirely depend on her. If you are married, it depends whether your husband or your husband is agreeing whether you go to the TRRC to give a statement or not. It's not solely depending on the women. And some women would come and say, I do want to go and give a statement, but I worry, how would that impact the rest of my family members? I have a daughter who is attending the university. What would happen to her if I come out and then the TV and everybody knows? We also, a lot of people, because of the weak enforcement of the laws, a lot of people worry that even if they come out, basically what women would say to us is that, what's the point of me going out, exposing myself, and nothing is going to come out of it? We've seen where perpetrators are free. We are seeing some people that we know are rapists. They're still holding high positions. If I go and report and I expose myself and my family and nothing comes out of it, what's the point? So you have victims having all those worries. Also, lack of prosecutions. We have a lot of cases, not just in relation to past human rights violations on the Jame, like direct Jame and his entourage, but also at community level, you will see a brave family that goes forward, take a step and want justice. But because of the backlog in cases, sometimes these cases are not taking further, or it takes a long time. And as we've had Hadi mention, sometimes the pressure, if the case is not taken on quickly, the pressure that these families receive at home will put them off. They end up withdrawing the case. Hopefully this is something that Naffie can emphasize more on, because they work with these cases. But that is also another challenge, another reason why a lot of women who are victims of SGBV don't want to come out, because they think they would expose themselves and nothing really happens to perpetrators. The prosecution doesn't go right to the end. Go to the next one, please. And the truth-seeking techniques and the Gambia. As I was mentioning earlier, like the standard techniques that are being used, again, we're talking about cultural context. For a lot of women, so for instance, we don't even have a definition of rape in our local languages. And in the Gambian adult population, especially for women, we have over 40%, I don't know exactly the right statistics, but we have a very high illiteracy rate. People, when we talk about rape, we don't have to describe rape in our local languages. So when we talk about sexual violence, sometimes it is difficult for women, if the TRRC is on just the standard investigations of rape, they will miss a lot of cases of sexual violence, because sometimes women don't know how to describe the things that had happened to them. A lot of also witnesses, women are reluctant to come out and ask the TRRC because of these various reasons that I have given. So sometimes with the way the TRRC works, a lot of women fear that if they come to the TRRC, they'll be live on camera. Now the TRRC gives women options whether to be all witness, whether you want to be on camera or off camera. But at the community level, this is not very clear. A lot of victims think that as soon as you go to the TRRC, you're going to be on TV. As you all know, our TRRC is broadcast live on TV and everybody watches it. So because of that, it's a big change for a lot of women, their identity, even if they, as I said, Gambia is very small. Even if you promise women confidentiality and witness protection, it's still very difficult for people. So it is important that the TRRC improves on their techniques so that they can encourage more women to come in. I know I have 10 minutes, so go to the next slide, please. So as an organization, as a civil society organization, we are interested not only in the direct impact of JAME on individual victims. We look at how JAME's violations, especially around SGBV, affects the Gambian society as a whole. So when we look at SGBV, we look at the deeper root cause. What gave JAME the power and his entourage? What gives them the power within our society that they use to abuse women? Because we believe that in order to say never again, we must look within our culture and society to address those deeper root causes of sexual and gender-based violence, so that reoccurrence doesn't happen again. So we go to the community and we engage women through our safe spaces. We would go to a victim community. We organize sessions called listening circles, where we invite women, and it doesn't have to be just sexual violence. We provide these safe spaces where women can come and sit down and share their experiences of violence. And through this, we don't just focus on, because in the Gambia, when you talk about SGBV, a lot of people just think of rape. From my experience, what I find a lot of Gambian women cry about is, as Gambian women, being in front of a man, forced nudity, which was rampant during Jame's time. They would force to undress completely. A Gambian woman, a lot of them, that equates to rape. a lot of women would cry and tell you how much they suffered. But if you want to prosecute those crimes under our Sexual Offense Act, that is not covered. Forced nudity wouldn't be covered as a sexual violence under our laws. So we have problems of that. We also support victims through psychosocial support in our safe spaces and support them if they want to give statement to the TRRC. We provide them with a conducive environment where they feel confident to share their experience and their stories. We also work with traditional communicators at community level and religious leaders where they go out and talk to their communities about sexual violence and gender-based violence, and also remind people of what happened during Jammeh's time. We also want to hear what does justice mean to women. Like for a Gambian woman, some of the example, the women who were victims of the witch hunting, they would say to you, for me, justice is my community knowing that I am actually not a witch. How do you give justice to those women? For them, they would say to you, Jammeh being prosecuted makes no difference to me, because in my they already believe that I am a witch, and that stigma is still on me and my children. How for them justice means going back to their community and working and changing, dismantling those misconceptions that what Jammeh told them was that these people are not witches. So for those people, that is what is important to them. So we need to, for every individual, what justice means to the at the international level, for a rural woman who doesn't have food, who doesn't have a hospital to go to, they won't understand how that is justice to them, taking Jammeh and prosecuting them. So we need to really understand what does justice means at the individual level for a Gambian woman. So when we organize our community dialogues, these are the kind of things that we want to hear from women, and we write reports and share with the TRC. And in the areas of reparations, what does reparation mean to a woman? We find out what it means to them, and then we share this with our partners. Yes, I think that's it for now. I probably have gone more than 10 minutes, but that's it for me.
No, that's fine. Thank you so much, Fatou. We've had comments in the chat box that talk about how difficult but how critical it is to talk about these issues openly. So thank you so much for sharing. And for some of the participants coming in, Fatou really talked about a lot of the factors that GRC took into consideration when we were developing the BIS guidelines. And it was working with organizations such as hers that we could really make a locally led tool. So when she talks about intrusive investigation techniques, improper methodology, or addressing misconception about witches, these are all things that informed the guidelines that we developed in order to take a locally led approach to investigations and prosecution. So thank you again, Fatou, that was wonderful. I'm going to now pass over to our second speaker, Naffie. So Naffie is a state counsel at the Attorney General's Chambers and Ministry of Justice in the Gambia, and actually is one of the beneficiaries of our project in the Gambia. So she is going to talk a little bit about the processes of transitional justice and some of the legislative reforms currently occurring in the Gambia. So over to you, Naffie.
Naffie, you're still muted.
Sorry about that. I didn't realize. I said my name is Naffie Sisshoho Bangura. I'm a state counsel at the Legislative Drafting Department as well. I'm both a prosecutor and a draftsperson. So I'll be dealing with the legal aspect relating to sexual offenses. So I'll go straight to the presentation since we have limited time. Right. So I've extracted the definition from our existing Sexual Offences Act 2013, which defines a sexual act, and it means the insertion to the slightest degree of sorry, of a penis or of a person into the vagina or anus or mouth of another person. The insertion of any other person of the body of an animal or any object into the vagina or anus of another person, except where such insertion is consistent with sound medical practice carried out for proper medical purposes or cunnilingus or any form of genital stimulation. So basically, just to explain that this provision covers the slightest degree of act towards a person. It could amount to a sexual act. So I've summarized it to mean when a person who intentionally, under coercive circumstance, engages in a sexual act with another person, or causes another person to engage in a sexual act with the perpetrator or with a third party. So this would also mean, for instance, when even if you're not a participant, but you've encouraged someone else to perform a sexual act with another person. So the act also deals with or has highlighted the coercive circumstances where it could amount to a sexual act, and it says the application of physical force to the complainant or to a person other than the complainant, threats, verbal or through conduct, or the application of physical force to the complainant or to a person other than the complainant. 3, the threat, it could also be threat, verbal or through conduct intended to cause harm or other person or other than bodily harm to the complainant, or to a person other than the complainant under circumstances where it is not reasonable for the complainant to disregard the threats. The circumstance where the complainant is under 16 years, circumstance where the complainant is unlawfully detained, circumstance where the complainant is affected by, and it has listed the exceptions, sorry, the circumstances as well. So it says physical disability or helplessness, medical incapability or other inability, whether permanent or temporary, intoxication, whether by alcohol or drugs or other substance, which medically incapacitates the complainant, or sleep to such an extent that the complainant is rendered incapable of understanding the nature of the sexual act or is derived of the opportunity to communicate unwillingnessly to submit to or to commit the sexual act. Circumstances where the complainant submits to or commits the sexual act by reason of having been induced, whether verbal or through conduct as well, by the perpetrator or by some other person to the knowledge of the perpetrator to believe that the perpetrator or the person with whom the sexual act is being committed is some other person. Circumstances where the presence of more than one person is used to intimidate the complainant. Circumstances where, as a result of the fraudulent misrepresentation of such fact by a fraudulent conduct on the part of the complainant or by or on the part of some other person to the knowledge of the perpetrator, the complainant is unaware that the sexual act is being committed with him or her. So these were extracted from the Sexual Offences Act, and it has laid out what is considered to be a coercive circumstance. And also with this, it attracts different penalties as well. But I didn't think I would get into those penalties. So I've just indicated the requirements to prove sexual offenses. So this is when we're prosecuting cases in court. So you see that we have the Evidence Act of 1994, where Section 8 requires that corroboration is required for cases of sexual offenses or indecent nature related to sexual offenses towards a person. So, but then these are the situations we face. You see that we'll go to court. Sometimes we have negative feedback from the public or the AG chambers is not doing this, the AG chambers is not pursuing this particular person, when we can only act when we feel that by a legal opinion that we are satisfied that when we go to court, we might at least secure a conviction, and we won't just be going to court just for the sake of going to court, when we're also restricted by the Evidence Act. Because if you don't have a corroborated evidence when it comes to sexual offenses, when it comes to rape, for example, there's no point going to court, because then you're required by law that the corroboration is needed. So when that is absent, then it really becomes futile when you go to court. So this section makes it also impossible to give a rape case, to prove a rape case before the courts. Most victims find it difficult to have their testimonies corroborated, and this greatly affects the prosecution of these cases, because usually it's just the victim and the perpetrator there's usually no third party involved or present, so it's very difficult to have corroborated evidence. So we usually rely on medical reports, which are not even satisfactory at some point, because usually it just states whether the hymen is broken, whether there has been a bruise, or whether how many finger insertions can go inside the vagina of the victim. So and we don't have DNA facilities as well to prove whether there has been a semen or any sort. So it's very difficult to prove such cases. These are the things that we face every day when we go to court, when we're writing our legal opinions. So even there are certain files, we have to send them back to the police because we can't prosecute based on the available evidence we have in the case file. So however, Section 7 of the Sexual Offences Act 2013, which is the latter act, abolished the cautionary rule, making corroboration evidence in rape cases no longer a requirement, although the Evidence Act is yet to be amended. But then, and then this is also something that this provision is yet to be challenged. We even had this discussion today at the weekly council meetings at the conference room, where I've briefly indicated that since the abolition of the cautionary rule in the Sexual Offences Act, probably we council could challenge this in court to see how best it could be accepted by the judges, because the judges are still inclined with the fact that you need corroborated evidence to secure a prosecution in a particular case. So after consultations with the Global Rights Compliance, we've been working closely together, and we've also had discussions related to this particular two provisions. That's the Section 180 of the Evidence Act and Section 7 of the Sexual Offences Act. And it is appropriate to state that even without an amendment of the Evidence Act, there is a legal ground to argue that the provision is in line, because the latter acts usually takes precedence. So we can rely on that when challenged by defense counsel. So it is my considered view that the provisions of Sexual Offences Act is consistent with international best practices by removing the necessity to corroborate a witness's account or testimony of sexual violence. This insertion is evidence in Rule 63 sub 4 of the Rules of Evidence and Procedure of the International Criminal Court, which the Gambia is also a signatory to the convention, and we're even on the verge of having it domesticated. It's before the Assembly now to have the International Crimes Bill 2020. So hopefully by then we'll have it as part of our laws as well. Okay, these are the legislative reforms we have so far. Since this new government, we've been doing a lot of reforms, and we've been amending a lot of provisions or acts that are discriminating against women. So we've worked on the Criminal Offences Bill, which is still before the Assembly. We have the Women's Amendment Bill, which deals with different aspects of violations or discriminations towards women. We have the Domestic Violence Bill. We have the Criminal Procedure Bill, the Anti-Corruption. We have the Prevention and Prohibition of Torture Bill as well. These two, the Prevention and Prohibition of Torture Bill and the International Crimes Bill, these are both international legislations which we're trying to domesticate. And we have the Married Women's Property Bill and the Tourism Offences Bill. All this bill deals with provision or contains provisions that are discriminating against women, which we're trying to repeal. So in addition to the legislative reforms, which are part of the transitional process, the government of the Gambia seeks to restrain and inhibit these laws that deal with sexual offences by repealing and or replacing them in order to facilitate and promote the protection of victims. Yeah. So The next slide is expected outcomes by the Ministry of Justice in relation to the Basic Investigative Standards Gambia project. So as I've stated, we've been working closely with GRC, and we've been having a lot of meetings, and we currently undergoing a training which we should conclude by Monday. So what we expect, what the Ministry of Justice expects, is to have trained and experienced prosecutors for the prosecution of international crimes after the TRRC, and hopefully by then the National Assembly would have also passed the international crimes bill. So that would really help, and with that also we could even have international persons or judges that could also come within the jurisdiction by the act, and then we could have probably hybrid courts, and these are things that are possible and could happen when we have these this bill passed or accepted by the Assembly. And also what we expect is to have, and it's already on the pipeline anyway, I'm sure Ashley could or Ruby could confirm that we're almost done with that, that's to have a manual and an app software, software containing resource materials and best practices to support our work in all aspects of the prosecution of international crimes. So these are the things that these are the outcomes that the Ministry of Justice expects, which are even already on the ground, and they're almost in the verge of being completed. Okay, so we have my next slide is the importance of localizing justice for international crimes, particularly sexual offenses crimes. So apart from the transitional justice process, the Gambia has set up the following justice mechanisms. We all are aware of the TRRC. We have the National Human Rights Commission, which is an independent body. It is independent and also permanent, unlike the TRRC, which is temporary. We have the Victim Center, although not set up by the government, but then it was set up by victims and human rights activists. So these victims were victims of the previous regime. They could be political, they could be sexual offenses.
We lost internet connection. Could you go for it, Ashley?
Yeah, sure. I was just going to thank Naffie for her comments, but I'm going to save that and hopefully she'll connect a little bit later. Naffie's presentation really streamlines well into our last speaker, Ruby, who has been, she's one of the consultants with GRC and has been part of the delivery of the project that Naffie was just mentioning there, and in particular in drafting the sexual and gender-based violence section of the BIS manual and the app. So she's going to speak a little bit about our experience in creating that manual and the app for the prosecutor's office, and just a follow-up on how important it is to ensure that sexual violence has been really culturally situated in the guidance that we give. So over to you, Ruby.
Thanks, Ashley. And just before I start, I think I've seen Naffie come back on. If we want to switch over to Naffie, I don't want to cut her off, but I think she's back.
Yes, I think I exceeded the 10 minutes because I wasn't done with the presentation. So I don't know whether I should continue or...
No, continue before I start, yeah.
Yeah, I'm almost done anyway. I'll try and be faster or quicker. Let me see, let me go back, then I'll have to share. Okay, so I was just going through the experiences the challenges we go through. So I was explaining the inavailability of the witnesses. I think I've seen it in Fatou's presentation, where sometimes we record all their statements, but to have them to come to court is a problem. Or sometimes they promise you that they'll be in court, you'll be in court waiting for them, and they'll switch off their phones, and then that's just, so sometimes the judge gets pissed off and just strikes out your case. So these are the experiences we go through. And also the interference of family, the victims of family members. Sometimes they'll call you or come to the office in large numbers, trying to convince you to drop the case, or we don't want to go through the case. And when you refuse, then they'll make the victim not available as well. And what's a case without a victim anyway? How can you prove that this act has happened when the court can't even see the victim? Sometimes it's insufficient evidence. still takes me back to the fact that we don't have the mechanisms of conducting the DNA test. We don't have, when it comes to rape and then a baby is involved, we even have those cases in court, and it's so difficult. And proper investigation and gathering of evidence. This goes back to the police, because we don't carry the investigations, they do. So sometimes it's inadequate and just not properly done. And sometimes it's so sloppy that even to record statements or cautionary statements without the independent witness, so that those cautionary statements get struck out of court or not being admitted. So it also affects the case. And timely conducting of medical examination, this also is a problem, because sometimes you are raped today, you'll go to the hospital and they'll tell you, oh, go back tomorrow or come back in 2 days time. So by the time you go back to the hospital, maybe you have healed, there is no bruise there or anything to show that you've been violated. And the duration of cases, sometimes they take a lot of time, and it's also a problem. And the in-depth or comprehensive understanding of sexual offenses by judges or magistrates, because sometimes, like I said, with the issue of corroboration, they feel that there should be the evidence should be corroborated, which also affects our cases. So I'll just briefly go through the patriarchal attitudes within the Gambian society, that most Gambian settings is dominated by male leaders, and also this can be broken down anyway if more women are involved, if more girls are brave enough to report these incidents, and also they've seen results being they've seen results from those that have already reported. I think Fatou has dealt with this area as well. It can also be effective when male members from the family, victim's family, are also involved in the whole process. They've initiated the report, they've pursued it up to the end, and also to have continuous awareness, raising sensitizations when it comes to the existing laws and the avenues they can take to seek a remedy. And the culture, whether the culture is superior to the law as well. And this basically sometimes, especially the rural area, I think culture supersedes the law, because when these things happen, it's the families that sit together and discuss the way forward. And sometimes you as a victim, you're not even considered as part of the conversation, or you're not part of the conversation. So they take these decisions for you. So at the end of the day, the law is not even considered. So this is also a problem. And I think sometimes it just supersedes the law, or they're not even aware of the existing laws. So why are sexual offenses cases unreported? So based on what I've just said, sometimes it's the stigma, the shame, the discrimination attached to these kinds of violations. So you'd rather not report the case because maybe you'll be discriminated against, or you might even not get a husband out of it when you're pointed out as someone that has been raped, or more a virgin, because these are all things that most societies hold really highly. So it's a problem as well. So sometimes they rather just keep it to themselves and not just report or say anything about it. And also family pressure, which is, we call it locally as the maslaha syndrome, which also links back to the culture of silence, because you rather keep quiet and just deal it internally than having to expose the perpetrator. And also dependency. Some of them are also, they're unemployed, they're uneducated, they're so dependent on their male folks that when they report these matters, they might get sent out of the house. At the end of the day, they'll just have to suffer the consequences on their own. I'm almost done. So why is marital rape not criminal in the Gambia? So for this reason, for this area, I think it's because the religious leaders are yet to accept this notion that a husband can rape their wife. That's the main issue, because most of the time, just people get to accept certain things when it's accepted by their religious leaders, or they've been told by their religious leaders. So this is still a problem, and it's still in the Sexual Offences Act, although there are potential proposals of deleting that particular area which states that rape shall not apply to married couples. But then even when it's been deleted, there is no other provision. I'm not aware of any provision to replace that, to replace it, indicating that marital rape is criminal. But I think it's also a step to just having the law silent on it. Then probably it could be challenged in court that since it is silent, it could be deemed as if it is criminal. I don't know. That's my opinion anyway. So what can be done? We have continuous capacity building. when it comes to the prosecutors, to the judges, to the public, everyone. I think we should, and even the CSOs as well. Everyone is involved when we have continuous capacity building, awareness raising across the length and breadth of the country, through using this local media as well, and also to inform people of the existing laws and the avenues that they can take to report certain cases. Yep, I'm done. Thank you.
Yeah. Naffie, that was wonderful. Thank you. We've actually had some really interesting questions come in through the BIS app, which I might have to come back to you after. But for now, we can just pass it up to Ruby.
Okay, well, thank you. And firstly, I just wanted to say thank you to our Gambian speakers for their fascinating presentations, but also their support through the whole of the project, particularly their insights and knowledge on the issue of sexual violence. Their willingness to share this knowledge with GRC was really invaluable to the successful completion of the project, and I think a real testament to the importance of local input in achieving sustainable peace. So transitional justice begins and ends in the affected communities where the violations took place. And as such, the aim of GRC's commitment in the Gambia was to contextualize the best practices and principles that are core to the BIS and to the local legal, social, political, and historical context. So in order to achieve this, we implemented our project in 4 distinct phases. And the first of which was a comprehensive needs assessment and local consultation, which is where we spoke with the prosecution, with CSOs, and also international NGOs active in the country. And at the outset, we soon realized that the international human rights and criminal law standards and best practices in investigating and prosecuting are relevant to prosecutions of domestic sexual offences, as well as to international crimes. And so because of that, we decided that to be truly useful within the Gambian context, we would broaden the parameters of our work by analysing domestic law, primarily the Sexual Offences Act, which Naffie has just discussed. And we'd analyse that in line with international best practices, as well as including information on international crimes of sexual violence as well. So this was critical and important in our project. And our hope is that it will not only enable effective and victim-centered handling of sexual allegations which arose during the Jammeh era, but also continue to contribute in a small way to empowering prosecutors in their work to assure accountability for sexual violence against women, which are still prevalent in the Gambia today. And so these consultations that we did at the beginning then fed into the second phase, which was drafting the manual. And the manual's intended to familiarise prosecutors with international standards. And there's a specific sexual violence section in there, which deals with sort of analysing international and domestic best practices. And then that then fed into the third and fourth phases, which were firstly to create a training curriculum. And we did about 2 weeks worth of online training, which Naffie also discussed. And then also we're currently in the process of finalising the BIS app for the Gambia, which should be available for download in a few weeks' time, hopefully by the end of the month. So, as I've mentioned, throughout these different phases, we encountered various challenges in ensuring our guidance on sexual violence was culturally situated. And this was really an aim we had, and sort of our primary concern really was to ensure that all of our guidance was culturally situated. And although that we tried to do that throughout the whole manual, it was particularly important for us to do that within the sexual violence sections. And I'd like to touch on just a really small handful of some of the themes to try and illustrate how we were able to harness local understanding and combine that with international best practice in order to produce the contextualized BIS. So to begin with, our research and local consultations revealed that survivors often may not come forward because of a lack of understanding of what sexual violence involves, and that it involves conduct beyond rape and includes even non-physical acts. So we utilise the Hague Principles on Sexual Violence, which, if you don't know what the Hague Principles are, they were developed through consultations with over 50 global civil society organisations, and they develop a survivor-centred understanding of what constitutes sexual acts in order to broaden our understanding of all the different behaviour and conduct that can amount to sexual violence. So applying the Hague Principles to local cases, the BIS now contains contextually situated guidance on the different acts, both physical and non-physical, that can be identified and charged as sexual violence, both domestically and internationally. So both as domestic crimes, there's indecent assault in section 126 of the Gambian Criminal Code, and also as international crimes under the Rome Statute through other forms of sexual violence. And so one of the studies that we tried to utilize case studies as much as possible. And one of the case studies that we used here was evidence from the witch hunts, where elderly women have described being forced to strip naked by young soldiers, as well as being forced to bath naked and being washed with water over their naked bodies by these young soldiers. So that was one of the examples of other forms of sexual violence that sort of went beyond just traditional understandings of rape. The second theme that I want to pick up on is ensuring a broader understanding of consent and coercion. And we realized that this was needed when dealing with sexual violence crimes. The issue was particularly raised by civil society, who explained to us that many women don't recognize conduct as sexual violence, or they believe that they're to blame in various ways when they've been sexually abused. We therefore wanted to ensure that the guidance we were providing was encouraging a comprehensive and context-based investigation of sexual violence cases to ensure the full scope of criminality is captured in cases that fall outside of traditional categories of force or threat of force or helplessness. So this broad interpretation of coercion, so through this broad interpretation, we were able to offer practice that hopefully will allow a greater number of victims of coercive abuse to access justice. But it was no use just simply providing a list of coercive circumstances that has been recognised under international criminal law and that we recognise in The Hague, but may have no resonance at all within the Gambian context. So we therefore brought these ideas into training sessions that we've completed and applied them to local case studies. In particular, how the former president Yahya Jammeh abused his power and authority as president and his extreme wealth to take advantage of vulnerable women and girls who he hired through his protocol office. And we had really interesting discussions during our training on this, and sort of, discussing the different types of coercive circumstances that are recognized in international criminal law and how these can be interpreted also within the Sexual Offences Act, which Naffie showed, and all the different coercive circumstances that are also recognized there. And the final illustration is that of corroboration. And because Naffie was so comprehensive in her explanation, I'm really just going to mention the fact that this is something that we considered in depth, and it was something that we took a textual analysis of international law as well as Gambian law to try and basically create a pathway to ensure that Gambian law can be interpreted in line with international jurisprudence. And it's hope, based on the training sessions that we've completed, that prosecutors will be able to utilise these arguments in court, as it really was, I think, every single one of the needs assessments we received, and also in our discussions with civil society and other organisations, this was universally raised as one of the main issues and one of the main challenges to sexual violence prosecutions in the Gambia. So hopefully the pathway that we've created, or not that we've created it, but that we have analysed in our manual, will hopefully be really useful in that. So what I've discussed today hopefully provides an insight into the processes we went through to provide a contextualised BIS manual, training curriculum, and also app for use in the Gambian context. And while it was extremely rewarding for GRC, it was not without its challenges, particularly in the global context of COVID-19, meaning that we were not able to go to the Gambia at any point, and the training that we'd planned in the Gambia was obviously not able to take place. So despite our inability to travel to the Gambia, we got a bit inventive with our means of communication, and we've all been engaged in a number of WhatsApp and Zoom calls, as can be expected in this sort of new reality that we're in. We also managed to conduct online training over the course of 2 weeks, which, despite not being as expansive as we'd first hoped, because we had first planned to sort of be in the Gambia, we hope that this was well adapted to suit this new reality and online learning. We also hope that the BIS app, when it's released, well, the Gambian version of the BIS app when it's released, will respond to these new challenges as well. So the app, as I said, will be available to download by the end of the month, and it's hoped with this online distance learning tool, Gambian prosecutors and also civil society will be provided with the means to continue to broaden their use of international standards and receive mentorship, ongoing mentorship with global rights compliance in a sustainable and also COVID-safe way. And on that note, I'm over, and I just want to thank you all for listening, and also to thank the Gambian speakers again.
Thank you so much, and thank you, Ruby. And unfortunately, we've had lots of interesting questions come in through the BIS app, and also a few through the chat. So I might connect with KMF later and see if there's a way that we can compile the Q&As that were unfortunately not able to be answered. So I will just do a quick wrap up to say thank you so much to KMF for their continuing support on the BIS, and to our Gambian speakers for your involvement in the project. It's been invaluable, and I hope that what we've done is broaden a little bit of the scope and opportunity for successful prosecutions to address the ongoing impunity that's been happening in the Gambia. So I have been asked if everybody feels comfortable to turn on your videos and to give a wave that will be included in the final cut of the I think the KMF wrap up. So if everybody's comfortable to do that, then if we could just take a minute to switch on. No one's going to judge you if you're in sweatpants. So thank you very much to everybody for attending, and name and contact details will be floating around, so please reach out if you're interested in receiving the manual and the BIS, and stay in touch with us and our speakers. Thank you.
Thank you guys. Fantastic. Thank you so much.
Really interesting. Thank you.